finally, in this section, I'm going to move on to fees in relation to appeals. Often it's asked in events cases, well, how do we treat the costs in relation to where there's, for example, an interim appeal from a fact-finding decision? And the answer to that is that those become a discrete schedule of costs that can be included as part of the events model. It's so essentially, once you're heading for an appeal, you need to send to us a schedule of costs based around hourly rates for the work that's going to be done in relation to the appeal. It needs to be sent to us fairly promptly and in advance of the work being done. And that then gets included in the case plan. Now, that is likely to be an interim case plan for obvious reasons, because obviously until the appeal's been determined, you're not going to know what the final outcome of the case is, and the case is likely to run on. But prepare that discrete schedule, obtain counsel's estimate of costs so that you can prepare that properly, and include that with your own anticipated work calculated at hourly rates. Rebecca, Chris, Scott, again, free for you to come in here.
I'll only add, where you have authority for QC and junior, or authority to counsel, doesn't necessarily give you the right to have to counsel at an interim appeal. You need to speak to the legal aid agency about whether or not QC would be covered to attend, because they would then have to be told what the nature of the appeal is, and whether or not it actually qualifies for a QC plus junior or QC alone or junior. I think there's this, again, unfortunately, usual word, but there is this misconception, because for junior only cases, interim appeals are naturally covered by your current legal aid certificate. It seems to be that because you've got prior authority, you think you're also covered for QC as well. This is not the case. Again, could become quite expensive if you turn up at court and then you find out that actually you're not covered. But I'll now pass back to Angie just to go over the detail of that. But I know this has been an issue over the last few years, shall we say.
Thank you, Chris. I do appreciate you for highlighting that. Yeah, let's cover that fairly quickly. Yes, the authority ends at the end of the fact-finding hearing, so it will not extend to the appeal hearing. Now, we do need to understand what the issues on appeal are if we're going to grant that authority. It may be that the issue on appeal is a very, very straightforward point to take, and maybe very easy for junior counsel to cover off. It may not be necessary for Queen's Counsel to do the appeal. Equally, because of the nature of the appeal, it may be, again, very narrow. It may be technical, but it may be very narrow and not involve a huge amount of work. So again, it might just be appropriate for Queen's Counsel to do that part of the appeal hearing themselves without junior. So in that context, the LAA need to understand the issues around the appeal so that the appropriate level of authority can be granted. We try not to make it as onerous as in maybe that appears in the initial application stage for prior authority. We try to keep it lighter touch, but it's much more a case of really understanding what those issues are, how the appeal applies to the criteria, so we can understand and make that call for you. And of course, there may be an issue that once the appeal has been dealt with, it might be that it goes back to another fact-finding hearing, but the appeal might have addressed issues that were the real complex issues in the original fact-finding hearing. It's potential. So it could arguably reduce the need for Queen's Counsel in relation to a rehearing of the fact-finding hearing. Equally, you might find that where there was no Queen's Counsel involved in the original fact-finding hearing, suddenly there are issues as a consequence of the appeal, although the appeal's taking place, which might justify the Queen's Counsel's involvement in the rehearing of the fact-finding hearing. So all those permutations are possible, but it's about addressing that criteria in relation to the next stage of the case so we can understand it. I'll pass you back now to sort of Chris and Rebecca to come in, and to Scott as well, just to add then when we're talking about any other aspect of the appeals schedule and detailed costs. Anything you want to pick up from that?
I'm very happy with my, with my bit on that. I'll leave it to Rebecca and Scott.
Just a practical bit of advice from me on that one. If you have a look at the Legal Aid Agency's website and you have a look at the case plan that's on there, you'll see that there's a separate section for you to include your appeal costs at hourly rates. That's a great place to look, because it'll give you a good indication of how to break that down, and obviously council's fees as well.
Yeah, and on a technical side, because I've had a case very recently which had just this. It was a high cost events case, so the case plan's got all the events, then it's got the appeal fees in section F, that's ready to go. So when I was submitting it on CCMS, I'm so used to putting all the events in, I got to the bit with to put the appeal fees in. I thought, oh, how do you do that? There is a fee code or an entry line which is hourly fees which escape events, and that's what it says, and it's at hourly rates, and you put the hourly rate in and the total claimed. So it's one of those things to keep an eye out for when you're submitting your final bill and there are hourly rates costs in there. You don't submit two bills, it's all on the one bill, all on CCMS. There's just a separate question that you have to answer rather than the events one, so it's one to keep an eye out for.